Court is calling 2023 CR 3544, State of Texas versus Garland Green. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Robert Geary, Your Honor, for defendant Garland Green, and we're ready.
Are you Mr. Green?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Green, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
In a quiet Texas courtroom, the case of State versus Garland Green is called. Prosecutors and defense teams are present, ready to proceed. Mr. Green, facing serious charges, confirms his readiness before the judge after verifying that discovery materials had been shared and understood. The court determines the state has complied. As Mr. Green stands before justice, his legal journey begins not with defiance, but with cooperation. The courtroom prepares to hear a plea, not a trial. Subscribe now to follow real courtroom drama, legal insights, and human stories behind every case.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation as a Class A misdemeanor? The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this?
Mr. Green is handed a series of legal documents, among them the true bill of indictment and a request for deferred adjudication. One by one, he confirms he's read, understood, and signed each form. With his attorney, the judge skips reading the indictment aloud as the defense waives the formality. But the courtroom shifts when the state announces a reduced charge: assault, bodily injury in a domestic context. It's still serious, classified as a Class A misdemeanor, but the change hints at negotiation. The defense raises no objection. The legal course is narrowing toward a plea.
Plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your
Do you
Honor.
believe he's currently competent and was legally sane at the time of the offense?
I believe that he is and he was, Your Honor.
Mr. Green, has anyone threatened?
The judge ensures Garland Green knows what's at stake: 1 year in county jail, a $4,000 fine, or both. But this isn't just about jail time. Mr. Green acknowledges the rights he's giving up: trial by jury, the right to remain silent, and the ability to confront witnesses. He confirms his choice is voluntary. His attorney vouches for his competency and sanity at the time of the offense, with no promises beyond the deal and no coercion alleged. Mr. Green's path toward resolution seems solid, at least on paper.
Right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge, there have not.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be no contact with Jesse Wheeler, JESSIE WHEELER, the BIPP program, and anger management. Did you understand those were conditions that the state is recommending and the court does not have to follow that? Then to the lesser included offense of assault, bodily injury, married, cohabitation. How do you plead? Guilty, not guilty, or no contest?
For the plea comes with weighty consequences. The court accepts a deferred adjudication, meaning no conviction today, but it could return. A key component, an affirmative finding of family violence. Mr. Green is told this finding affects his future: no firearms, no primary custody, no second chances if conditions are broken. Meanwhile, the complainant, Jesse Wheeler, has signed an affidavit of non-prosecution and refuses to cooperate. Still, the case moves forward. Evidence is admitted without objection, and Mr. Green signals understanding of every term. The courtroom prepares to hand down judgment not of guilt, but of conditions.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements or police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge. In regard to the no contact order with Jesse Wheeler, the parties are cohabitating. They do share a
Script 5, Mr. Green pleads guilty to the reduced charge. He signs away his right to live testimony, allowing only reports and affidavits to serve as evidence. The court finds the evidence sufficient to prove guilt, yet pauses a deferred finding now stands between Mr. Green and a conviction. This is his chance to avoid a record, but it comes with a promise, full compliance, any misstep, and the consequences come roaring back. The legal machinery has spoken, but sentencing is still ahead where the court will weigh punishment, protection, and the lingering pain behind every act of violence.
5-year-old son who just started school yesterday. My client works at Pepsi during the day. Mother works for Rackspace at night. So the no contact order would impose an unduly burden on the parties in respect to parenting this child. As is usually the case, Your Honor, in these situations, CPS was involved as per family-based service plan. The parties went to counseling. My client went to counseling and is continuing to go to counseling. Both parties have been and are attending marriage counseling at this time. My client says that it's been
Makes a heartfelt request, lift the no contact order with Jesse Wheeler. They share a 5-year-old daughter, split parenting duties, and even attend counseling together. But the judge is unmoved in a powerful moment.
good influence on both them and their relationship. And they feel that the no contact order, if implemented, as mentioned, would be a burden not only on their relationship, on their status, but their ability to parent the 5-year-old child. So we respectfully request that the court not order a no contact order. Thank you.
All right, so is this a son or a daughter? Because I was reading the report, it was a daughter.
Little girl, sorry.
Okay, no problem. I want to make sure I have it right. So what family members do you have in Bexar County?
I have my mom, my dad, but my dad, he doesn't really help out much. My mom, she really can't because she can barely move around herself.
She highlights the trauma inflicted on children who witness domestic conflict. A 4-year-old doesn't forget, she says, calling out both parties for immature and damaging behavior. Her voice is firm if Jesse Wheeler wants the no contact lifted. She must appear before the court herself. A reminder that justice isn't just about punishment, it's also about protection.
I want you to understand something.
Yes, ma'am.
I read the police report, and in the police report, you said she was pushing your buttons, you're pushing her buttons, and you can unfold your arms. And all of you all were acting not as adults, y'all were acting like children. And the child at the time was 4 years old. You all caused drama and trauma to a 4-year-old. What is a 4-year-old supposed to think? And you and the complainant are going through the apartment, throwing things around. And you tell a 4-year-old, don't throw that, place it back where it's supposed to be, and trying to lay down the law to a 4-year-old. And you all are acting worse than the 4-year-old.
Yes,
Mr. Green is handed 2 years of deferred adjudication, not freedom, but conditional liberty. He must complete a batterer's intervention program, anger management, and parenting classes, 80 hours of community service. Unless classes have already been completed, the judge adds drug testing, 3 field visits, employment verification, and bans on working with vulnerable populations. These aren't just boxes to check their safeguards. The court is sending a message. Change must be proven for Garland Green. This isn't an end, it's a narrow bridge between guilt and rehabilitation.
So a daughter will begin to think, oh, this is how somebody who loves you shows that they love you. They're abusive. And then your daughter goes out in the world. And if she ends up with, as my professor in high school would say, and I say professor because he was a doctor who taught us physics, he would always say, girls, do not end up with a joker. So your daughter may end up with a joker. Don't let her be you be the reason she ends up with a joker. And he would give instruction to the guys too. So you've got to do better. You understand?
I understand.
All right. Thank you.
Thank you, Judge.
You're welcome. Michael Ball.
The judge delivers a piercing message. You will be the reason your daughter ends up in an abusive relationship unless you break the cycle. It's not just a sentence, it's a warning. Mr. Green is reminded of the rights he's waived, the weapons he can never carry, and the future he's still shaping with every choice. He nods, acknowledging the court and thanking the judge. The hearing ends, but the story continues. One man, one family, and the shadow of violence they must all learn to live beyond. Like, subscribe, and stay tuned for more courtroom stories that matter.